Hello everyone, I'm Pooja from the Agni team, Accelerating Growth for New India's Innovations. Agni is the National Innovation Commercialization Program, and today we have a first webinar. We'll be talking about patents today and answering all the questions that you guys have submitted. And we have with us Siddhant Choksi from the CPAM team, and handing over to Siddhant now.
Thank you, Pooja. Hi, I'm Siddhant Choksi from Cell for IPR Promotion and Management. It is under Ministry of Commerce and Industry. And today we are going to talk about patents and what are the basic things about the patent and what every innovator should know. So I'll start my presentation. During my presentation, I'll try to answer all the questions which you have submitted. And after the presentation, I have selected few questions which I am going to answer. So first of all, what is intellectual property? So there's a slight difference between intellectual property and intellectual property rights. Intellectual property means whatever you are creating from your intellect, whether it is image, whether it is an invention, books, paintings, the creativity and the innovativeness, when it comes into the tangible property, tangible material, it can be protected through intellectual property rights. So that main difference between intellectual property and intellectual property rights is there are some rules and some act is properly defined for protecting some creativity, for protecting innovation. Those are called intellectual property rights. And these rights are territorial in nature. If I'm saying territorial in nature, it means if you have filed patent or trademark in India, it will be applicable in India only. So let's move on and see what are the type of intellectual properties we have. So these are some of the main important type of IPRs like patent, copyright, industrial design, trademark, geographical indication, and trade secret. And most important for the innovators and favorite one is patent. So we'll be talking about the patent today. So I'll focus on that. All right. So patent. So patent is a statutory protection or the protection given by government to the innovator to protect his invention from others, from stealing and selling. Others can't sell your innovation if you are protected through patent. It is applicable only for 20 years from the date of filing. So patent gives you the monopoly for 20 years. You can protect others from selling it or using it without your permission. So it is a right which innovators get for 20 years. So if I'm saying patent, so not all the innovation can be patented. There are some exceptions and some criteria for the patents. So we'll be talking about the exceptions. What are the types of innovation which can't be patented under patent law? So with the whole logic of creating this non-patentable invention or creating this criteria with the patent, like the innovation which can't be patented, is to secure the public, is to secure the moral rights. So I'll go through it one by one, but as a whole, the main purpose is to boost the humanity and through innovation, how we can develop further and help humanity. So the method of treatments of humans, of animals, can't be patented because if you patent method of treatment and if you monopolize on it, then it can create a havoc. Similarly, method of agriculture can't be patented. The inventions which are against the moral rights or which can cause serious prejudice to human beings, animal or plant life, they can't be patented. More importantly, computer program per se or algorithm, they can't be patented. But computer program only can't be patented. You can get a copyright on computer program, but computer program with an hardware, with an innovative hardware, that can be patented. So there's a slight difference, and this is very, very common question which I got from Mr. Ravi as well, that whether they can patent their application or not, mobile application. You can patent your mobile application given that it is combined. If it is combined with hardware, it is something innovative output it is giving, then you can go for a patent. Mere discovery of a new form of a substance can't be patented. So like if you discover cloud, let's say if nobody knows about cloud and you discover something cloud, it can't be patented because discoveries can't be patented. E equals to mc square can't be patented. Gravity can't be patented. More logically, if you think, if you like mix something, so if you have an umbrella and if you have a fan, if you combine both the thing and you claim that this is the umbrella with the fan, you can take the air and protect you from the rain, then this is simple mixture of two elements you are mixing, and there's not something very innovative in it. So mere mixture of two substance or two technologies or two devices can't be patented until unless it is showing something very positive or something very innovative, some substantial differences there from the simple properties of two elements. Traditional knowledge can't be patented. The traditional knowledge, for example, is like neem. Neem is having various medical advantages. It can't be patented because people know about it and they are using it from our ancient ancestors are using it. So all the traditional knowledge in our Ayurveda and these type of things can't be patented. You can't patent the presentation of an abstract idea. You can't patent the invention which are against the natural law. So like if it is violating thermodynamic law, or if it is a perpetual motion machine which can't be possible, it can't be patented. Business model can't be patented. So these are the few things which I have covered which can't be patented. Apart from that, atomic energy, under Atomic Energy Act, all the nuclear bombs or nuclear related material can't be patented. The logic is very simple, that we want to save humanity. The patent law is to boost the humanity and the innovation. It's not for creating the hurdle for our environment. So we have talked about the non-patentable invention. Let's look, if some innovation is not falling in these category, then it can be go for the patentability criteria. So what is the patentability criteria? So three things are required to grant you a patent, which is novelty, industrial applicability, and inventive step. So when I say novelty, your invention should be new. It has not been published or it has not been showcased across the world. Nobody has ever, showcased it, made it, or published in any document, whether he has not filed the patent, he has not published the research paper also. So if these elements are not there or these criteria is not there, nobody has ever done that, then it is a novel, it is a new. That is called novelty. Second is inventive step. Inventive step means you are creating something innovative on the existing technology, or you are doing something one step ahead from the existing technology or the process. The criteria for checking the inventive step is, one of the criteria is it should not be obvious to the person skilled in the art. When I say skilled in the art, so if I am an engineer, electric engineer, if some electric product is there, and it should not be obvious for me that by doing A plus B, it is producing C. So if it is obvious to me, it is very common thing, then it can't be patented. And third and most important is industrial applicability. It should be made made by the industry. It can be a mass produced, or if it is an innovative process, it can be practiced in the industry to create that particular item, that particular innovative product. So if these criteria are, if you are matching all of three of them criteria, and it is not falling on the non-patentable invention, then your invention can get the patent. So you have to pass the novelty, inventive step, and industrial applicability. And patent can be granted for the product or the process or both. So these are some of the patented inventions. So as you can see, the patent can be on the very simple thing like cloth clip, or it can be on a very complex machine like power trailer. It is an automatic harvesting machine, or one of the patent has been given to indelible ink, which is used in election, and Italy maker also. These are the very good examples from where you can see the simple innovation can also be patented. It need not to be complex. One of the questions we have got, that whether the innovation should be very complex to get the patent. No, it is not. Simple thing, a wall screw cloth clip, even some of the key driving mechanism got the patent, very simple one. So these are some of the patented inventions. So one of the question which we got, three people has asked this question is, what is difference between provisional patent and complete patent? So let me start with a provisional patent. So provisional patent is one of the way to file a patent. So in provisional patent, when you file the patent, from that date you disclose your all the invention to the patent office, and from that day your patent is protected. So from after that day, if somebody else is disclosing that patent or disclosing that innovation, they can't file a patent for the same. So you get the priority date. It is called priority date. When you file the patent, the day you file the patent, it is your priority date. After that date, if the same invention has been filed even in our country or some different country, it will not they will not get the patent. So the idea of provisional patent is there because when the researcher is not very confident, or he's doing the research, he's not completed the research, and he want to protect the starting idea or the starting innovation, and he want to work on it and make the prototype and further develop it, then he can go for provisional patent. So provisional patent gives you 12 months of time. So within a year you have to file complete patent. And the main difference between provisional patent and complete patent is, in provisional patent, you don't write claims. So in patent, what is claims? So if you see the patent document, at the end, there are claims. The claims are the legal, techno-legal language, which set the jurisdiction of the innovation. Just like you have a land, there's a map and there's a demarcation is there that this much land belongs to you. Similarly, in innovation, through claims you define that jurisdiction of your particular inventive step, your methods, or your innovative process. So that particular thing is complex thing, and you have to write in your patent, and the patent agent usually write the patents. So in provisional patent, you don't have to go for claims. It is not necessary. So you just have to disclose your all innovation in a simple writing, and you have to make sure that you have disclosed all the innovative step which you have taken to create some product or a process, and then you can go for provisional patent. You will get 1 year, and within 1 year you have to file complete patent. In complete patent, you have to write all the claims. So when to use provisional patent, when to use complete patent? So if your innovation is ready to be launched and you don't want other to use it, and you have not disclosed to anyone, then you can go for complete patent, because you are ready for a launch and you want protection. Then you should go for complete patent. If you think that your innovation is not that ready, or you're not that confident that we should go for patenting because it involves a lot of money, then you should go for provisional patent. You'll get 12 months of time. You can again reassess that you want to invest further money on that, or you don't want to invest. Then you should go for provisional patent. So these are the basic difference between provisional patent and complete patent, and this is somehow you can decide that whether to go for provisional patent or complete patent. So what if? So in the starting of my presentation, I told you that IPR is the territorial right. If I filed patent in India, it will be applicable in India only. If someone is copying your innovation outside India and you have only filed your patent in India, then you can't protect outside India. So so for that, you have to file patent, let's say in US, in UK, and in other country. So it will be very difficult for you, because in Japan you have to file patent in Japanese, you have to get it translated. In China you have to file a patent in Chinese, you have to get it translated. So so multiple times you have to repeat that activity if you go by country and file the patent. To solve this problem, World Intellectual Property Organization created a patent cooperation treaty in which 150 countries plus countries have already signed, and India is one of the countries who have signed patent cooperation treaty. through patent cooperation treaty, you only have to file one application in one language, and you have to file in one of the recognized office. So Indian Patent Office is one of the office who takes the PCT application also. And you have to file in one office, one application, and then in national phase, after some months, you have to choose the country, in which particular country you want to protect your innovation. And you can choose the country, pay the required fees, and with one application you can protect your innovation in multiple countries. So that is called PCT, and one of the very beautiful way for protecting your innovation in multiple countries. Because if you are a entrepreneur, or if you are a startup and you want to go multinational, and you see some market in China, in USA, in UK, and you want to file patent in all of the country, so PCT is the best route. One thing you have to keep in mind, that from the date of filing till 12 months, within that time period, you have to go for PCT. After 12 months from the date of filing, you can't go for PCT. So that is the most important thing for your business, for an entrepreneur to keep in mind about the PCT. So we have talked about the patent, and we have talked about provisional patent, complete patent, and PCT. So what are the benefits? Why you should go for patenting? So in this slide, I'll try to give you the rough idea about the patent and what are the rights you get. And in next slide, I'll show you the success story, how like people has actually earned from the patent and how powerful the patent is. So the patentee, the innovator or the applicant who has been granted with the patent is called patentee. Patentee can commercially exploit his potential product or the process, the innovative process. He can use it commercially, he can earn money from it. He can stop others from making it, from selling it for the particular period of time. For 20 years from the date of filing, he can stop others from selling it, from making it, or from importing it. So you get the legal right to protect it. And if someone is copying your idea or your innovation or your product, you can file a case against him, and there are proper laws is defined to which will give you the damages. The damages, when I say damages, the money or the loss which your company or the innovator has borne will be given by the defendant or the other party whosoever is infringing the patent. For that, you have to file a case, and there are proper laws are defined, and you can file a suit against him, and you can get you can reoccur the loss. Third, from the patent, you can earn money by licensing or by assigning or by commercializing. When I say licensing, it is simply like a rent. If you have a piece of land, you want to give it on rent, you can sell it. You can fix the terms and condition that you want to give it for rent for 1 year, and each month you want this much amount of money. So similarly, licensing is there. If patent is your intellectual property, and you can license it, you can sell it, you can assign it to other. So I'll tell you what are the ways of commercialization, and what are the terms we use while commercializing our patent. So in commercialization of patent, there are majorly three categories. One is exclusive licensing, non-exclusive licensing, and sub-licensing. In exclusive licensing, licensor is the patent owner, and licensee is the other party. Licensor assign all the rights to the licensee, and you will give all the right to the licensee for selling and making. You will not even yourself will make that product. You will assign all the licenses, all the power to the party A in this case. And we should, like it has been said that we should avoid the exclusive licensing, but it depends on the product and the company, the target company or the target companies which you are saying. In exclusive licensing, you'll be binded with one agreement. You can't assign agreement to others. So like you have a piece of land, you will give rent to one party only. In non-exclusive licensing, you can sign agreement with multiple parties. So you can assign it to A, B, and C. And set the terms and condition that every month you will get this amount of royalty. So that way the chances of earning is very high, because you're creating a competition as well as you are earning from each and every licensee. So non-exclusive licenses is you have to sign agreement with multiple parties. And then comes the sub licensing. In sub licensing, you license it to one party only, but you give him right to license it further. So you allow him to further license it to other companies as well. So in this case, if applicant license it to A, then it will be licensed it, he can license it to other parties XYZ as well. So these are the major three mode of commercialization or licensing. So now I'll tell you the success stories, the two success stories. Uh, so what is the, like, why patent and what is the power of patent? So this is the recent success story. Punjab State Council for Science and Technology, that is government of Punjab, has come up with hybrid bricklane technology. So the bricklane emit a lot of pollution and they are less efficient. So they came up with a technology which reduces the pollution and which increases the efficiency of the bricklane. And given the innovativeness of the technology and the environment which we have in Delhi, or the degrading environment, the Punjab Pollution Control Board said that you don't keep the monopoly in this patent, you just transfer the technology or just give the licenses, multiple licenses to multiple people only on the amount of 25,000 one time. So you just have to take 25,000 one time in the Punjab, and outside Punjab 50,000 one time, and you have to give the technology. You can't take every month some money. So they have done that, and they have successfully done that and transferred this technology to 300 bricklane owners, and they have earned 80 lakhs within a year. They have earned 80 lakh rupees, and you can see the patent number. It has been filed on 2017. So one of the questions which I got is whether if I have filed the patent, can I commercialize it? Can I start using it? Yes, you can use it, start using it, because once you file the patent, your idea is protected and you can start using your patent. You can start licensing it. You can start commercializing it. Just like this patent, which I have shown you, hybrid bricklane. The second very simple invention which we use on daily basis is ring pull cans, and you'll be astonished the amount of money the inventor got. So this can, the property of this can is you can easily open, pull the ring and open the Coca-Cola can. So this guy has invented this can and he has licensed it to Coca-Cola, and he only charged 1/10th of a penny per can. But we know how many can are Coca-Cola is selling worldwide. So this guy was making around 1,48,000 UK pounds, which is around 1 crore 30 lakhs in Indian rupees per day. This was the amount of earning he was having per day. So you can imagine the amount or the profit, or by just sitting at the home, by inventing and licensing it to the right company, how much you can earn. So these are the very successful example which I've shown you, and this is the power of patent. So the patent process is little bit complex, so I'll try to explain it here. This is the patent process in brief. So once you file the patent, after 18 months it will get published. It will get published. When I say publish, patent office will publish in their website. It's called patent journals. And after publication of the patent, other parties are open to, like, we publish the patent so that other can raise the objection whether this particular patent is violating my rights or not. So if it may be possible that you made some machine and accidentally you are copying someone else patent which was granted earlier, then he can make an objection against you, or other interested party can make an objection against you. After the publication, you have to go for examination. You have to pay some fees and file for an examination of your patent. When you file for an examination, patent officers will examine your patent in terms of novelty, inventive step, and industrial applicability. They will search all the patents, all the publication around the world, and see whether your patent is matching with that, or whether your innovation is matching with that or not. And then if it is not matching with that and nobody has filed objection, everything is resolved, you'll be granted with the patent. So patent filing is a little bit expensive because you have to go to the patent agent. You can't write the patent document if you are not trained at it, and if you are not, if you have not practiced it, because it's not safe. Because let's take an example of again of a land, and if you don't know how to make a map, and if you made wrong map, then your land will be taken by someone else. So similarly, if you writing a patent document, all the techno legal language has to be drafted very carefully, so that your patent has been like it's protected, and you are not surpassing others rights also. So this is very important, and some people has asked me that how to write a patent, how to write a provisional patent. For provisional patent, you can disclose your innovation in proper simple language and file for a provisional. But for complete patent filing, please refer to, please take suggestion from the registered patent agent. They are the expert, and they can write all the claims very carefully. So since patent is one of the expensive things, to boost the innovation and patents in India, we have created a SIPP scheme, which is called Scheme for Facilitating Startup Intellectual Property Protection. This is particularly for the startup. So all the startup registered under Startup in India initiative can take the benefit. So all patent, trademark, design, all the application can be filed, and you startup only have to pay the government fees. The startup has to be registered under Startup India initiative. Through Startup in India initiative, he will get one certificate, and that certificate he can show to the facilitators which have already been empaneled. I have added the link in the last slide of all the facilitators which have been empaneled. So there are 425 facilitators for patent and design, and these are very renowned patent agents, and 606 facilitator for the trademark. So you only have to pay the government fees. The lawyer fees or the patent agent fees will be borne by Government of India. So this is a very big advantage for the startup, as you know, for filing patent you have to pay a lot of fees. And another advantage which startup can get is expedited examination. So expedited examination is one of the route through which you can get your patent as fast as possible. And till date, 80 patent has been granted, and the fastest was 81 days. So from the date of request for examination, from the day you have filed for request for examination, from that date, within 81 days, that one of the startup got the patent. So this is one of the fast route, and expedited examination provision is only right now available for the startups and the applicant who is filing for PCT in India and choosing India as a international search authority. As you can see, there are a lot of startups who have filed patent. So there are 1,443 patents is being filed under the scheme. So startups should take the benefit of this scheme. So now I have talked about the patent process in brief, and now I'll tell you what is expedited examination, and we'll try to go through this process in more details. So when you file the patent, or when you file the provisional application, as I've already told you, when you file the provisional application, within 12 months you have to file the complete patents and complete specification. Then after filing the complete specification or complete patent, within 18 months the patent will be published, and then you have to file for a request for examination. After filing the request for examination, the patent office will also take care of the people who has raised issue against you, and then after getting the examination, first examination report will be issued. So through expedited examination, the examination time will be reduced for the startup. So this is one of the route which startup can take, and within few months your patent will be examined, and if it is all right and nobody has raised claim against it, then it will be granted. So this is one of the platform which we have created. Is called Technology Innovation Support Center. There are 6 such center which we have established. They support startups, innovators, and creators for filing their particular intellectual property right. They file patent, they file copyright, and other intellectual property as well. So the list and the contact details of these TISC, which is called Technology Innovation Support Center, I have given in my last slide, and you can ask them for their services. They will afford, like they will help you for filing the patent, and very affordable prices, because these are government recognized institution which we have established. So we are also going to launch a TISC portal, so that you don't have to go to the particular TISC, and there will be a website through which you can do get your prior art search done. You can file your patent, you can file your copyright, and this will be launched within a month or two. And this platform will have all the IPR facilitation related query resolution type of things, and it'll be connected with the industries as well, so that industry can also see your patents, and if they want to buy, they can buy it. So very soon, within a month or two, we'll be launching this portal, and we'll share the link with you once we have launched this portal, and then you can take advantage of filing application through TISC. It will be comparatively economical if you go for filing from outside. And the last, and this is one of the important slide, and a few of you have asked me to give you the relevant links for this, and which is very authentic. So first is CPAM link, in which you will find all the information about patent, copyright, trademark, intellectual property. There are very beautiful videos, brochures, presentation, which are very easy to understand. Then you can go to ipindia.gov.in. You can track your application from there if you have a patent application or trademark application. And for the SIPP scheme, there's a link. And the more importantly, frequently asked question for the patent. So there's a PDF of 100 questions which I have prepared on the patent. You can go to that also. And then for registering you as a startup under Startup India initiative, you can go to startupindia.gov.in. And there are 35 plus IPR assistance center who give IPR assistance to the innovator. You can get their addresses and the emails from cpam.gov.in, know your IP offices, and they will help you for filing the innovation. Last, not the least, the computer related invention. So a lot of startups are having invention in the field of softwares, and they are like, there are a lot of inventions which is in the field of information technology. So how you can go for patent filing for your innovation, this is clearly defined in computer related invention guideline, which was released in 2017. So that's it. I'll be taking some questions now. So few of the questions I have identified which is not covered in this presentation. So one of the question is from K. Satyadev. Is it patent can be obtained on raw idea or thought also? So it depends. So like the prototype is the product, ready product is not mandatory, but if you have a prototype, then it will be much easier to get the patent, because you'll be able to show the innovativeness and other things. So this is the simple answer from my side, I think. And what is this is the question from Abhijit. What is the fees for filing and drafting the patent in India and abroad? So all the government fees, you can get the PDF from Indian patent website, which is ipindia.gov.in. There all the government fees has been given. For the patent particularly, the lawyer fees can go from 30,000 to 1 lakh, depending on the patent agent you are referring with, depending on the law firm and the complexity of your innovation. So one of the good question which I got is from Nitya, which is, can we start marketing our product once we make patent application, or should we wait till complete patent granted by the IPR office? So as I've mentioned, the date you file your patent, you can start using it, you can start licensing it, you can start commercializing it. So that is very clear. You don't have to wait for the grant of the patent. So you can start commercializing your patent once you file the patent. One of the question from Mr. Sudarshan is, how long does it take to get patent approved under Startup India benefits? And my application says 5 years. So through Startup India initiative, you can take the route of expedited patents, and I have just shown you that one of the startup got patent within 81 days from the request of filing a request for examination. So for startup particularly, this route is there of expedited examination. If you want to get the patent as early as possible, you can choose expedited examination route. Having said that, once you file the patent, I am again repeating it, you can use your patent and commercialize it. And the last question is, does unique system designing involving software, hardware, networking techniques to assure learning among the students will be considered innovative enough for the patent? Yes, if it is qualifying the three criteria, which is novelty, industrial applicability, and inventive step, then it can be patented, because it is, as I can read your question, it will be the combination of a software and a hardware, so it can qualify for the patent if it is qualifying those criteria. So thank you so much for your questions. I hope my presentation will may have resolved your questions, and you can raise or email any queries to Agni team. I'll be happy to give you the answers through email. Thank you.
Thank you, Siddhant, for the presentation. And we really do hope that your queries were answered and you have a better understanding about the patent policies in India. So meanwhile, I'd request you guys to please follow us on Twitter, Facebook, and LinkedIn. Please visit our website, which is www.agni with a double I, .gov.in. Please write to us on agni.support@investindia.org.in, and we'll be happy to answer any of your questions and any queries that you may have. And Agni, as a program under the Office of the Principal Scientific Advisor to the Government of India, is dedicated to help the innovators in India in commercializing their products. And we do look forward to hosting more of such webinars. And thank you again and have a good day.